Amy Coney Barrett is making her presence felt on the Supreme Court early. The Supreme Court just decided 5-4 against allowing uh, state governments the authority to impose size gathering limits in places of worship during the pandemic. They struck down an order from Governor Cuomo of New York, which had restricted to 10 the number of people allowed in places of worship in red zones, which were uh, the 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 most ravaged districts by the virus, and to 25 the number of people allowed in places of worship in zones that were designated orange zones, which were less dangerous, less COVID ravaged zones. The court just decided to strike that down, those restrictions, as unconstitutional, unconstitutional um, challenges to the First Amendment right to obviously exercise religious freedom. Justice Gorsuch wrote that it is time, past time, to make plain that while the pandemic poses many grave challenges, there is no world in which the Constitution tolerates color coded executive edicts that reopen liquor stores and bike shops but shutter churches, synagogues, and mosques. And this case regarded two applications, one from a Roman Catholic church in Brooklyn, and the other from two synagogues, as well as an Orthodox Jewish organization, and two individuals who sought to enjoin these limits that, again, they felt were unconstitutional. And basically, what this comes down to is, and actually, I want to read what Chief Justice John Roberts, who is a conservative that has lately embraced his role as a swing vote in siding against his fellow right wing counterparts on the bench to side with the liberals. He dissented and had something interesting to say that actually was basically in line with something that he said in previous cases on this matter that were decided back in May and July, in cases that came out of California and Nevada. At the time, obviously, RBG was alive, so he had sided with the liberals, given them the majority, and at which time they upheld the right of government officials to basically impose laws, given their level of expertise and background relative to judges in assessing public health and reacting accordingly. They had previously upheld that right of government officials, and so now this is an about face that basically rules on the larger question of whether or not government officials or judges should be tasked with striking that balance between public health and religious exercise. And what I want to look at is what some interesting things that. Well, first of all, here's what Sonia Sotomayor here's what the who was this second dissent joined by just said Mr. Cuomo. Yeah. So Sonia Sotomayor had to say that free religious exercise is one of our most treasured and jealously guarded constitutional rights, and states may not discriminate against religious institutions, even when faced with a crisis as deadly as this one. But those principles are not at stake today. The Constitution does not forbid states from responding to public health crises through regulations that treat religious institutions equally or more favorable than comparable secular institutions, particularly when those regulations save lives. Because New York's COVID-19 restrictions do just that, I respectfully dissent. And so this was something that in an opinion issued by Chief Justice John Roberts, was echoed. He had, I wanna find his comment here, because he said, okay, so uh, it's a significant matter to override determinations made by public health officials concerning what is necessary for public safety in the midst of a deadly pandemic. If the governor does reinstate the numerical restrictions, the applicants can return to this court and we could act quickly on their renewed applications. And then he previously, in the decision in May, which upheld the California government's restrictions on size gathering at places of worship, he said government officials should not be subject to second guessing by an unelected federal judiciary which lacks the background, competence, and expertise to assess public health and is not accountable to the people. I want to come back to that point because that's an important point that I think resonates with a broader argument that I've made about our politics in our institutions and the way they function and the way they basically are designed as currently constructed to defer heavy political questions to the court, to again this unelected federal judiciary, because I think that the whole practice really says a lot about our democracy and the need for repair. But first, I just want to come back to I disagree with this particular opinion, with this decision, because I do believe that it's dicey not only to decide that unelected body of justices unaccountable to voters, that they should call the shots when they're obviously less informed and less able to assess public health guidance, just because again that's not their job, but also because in the case of New York in particular, the restrictions placed on churches, synagogues, places of worship were not any more severe than other unsecular places. So, there are many non-essential businesses that are closed. And even in the ones that have been allowed to remain open without capacity limits, those are very different sorts of businesses. We're talking about bike shops, liquor stores in which people do not congregate in close proximity for extended periods. So that particular logic, as it applies to this particular case, I think the court voted wrong. But more importantly, I want to talk about just the sort of act of judicial activism, which is, I think, the constitutional overreach that I think this sort of demonstrates, and the way it sort of follows a long tradition that dates back centuries in this country of deferring these really important social and constitutional issues to, again, an unelected federal judiciary that lacks, as in Justice John Roberts' own words, the expertise. Okay, so this whole concept of judiciary review, of judicial review, is not in itself based in the Constitution. It's actually something that dates back to a Supreme Court case, a Supreme Court decision, which was just a basically naked act of judicial activism. It was a power grab that was done in such a way to neutralize the objection that the Supreme Court should have such power to override government officials, to side with the, at the time, sitting president Thomas Jefferson, who very much opposed giving the Supreme Court that much power. He famously was very dubious of the Supreme Court's power. He said famously that the Supreme Court, the justices on the bench, have only as much integrity or morality as any man, and not more so. But because they understood his politics when it came to having that sort of hostility to the principle of judicial review, they went ahead and decided that, well, in this particular instance, the statute that was on the books that was passed by Congress conflicted with the Constitution, and so they were going to act in their capacity as a supposedly impartial, elevated arbiter of the Constitution. They were going to strike down that law that conflicted with the Constitution, and in so doing, establish a new precedent, wherein they would be these sort of morally transcendent arbiters of the law. And again, because they had sided with Jefferson, then they were able to neutralize his objection and sort of get him on board, as long as they were carrying out his political agenda. And so ever since then, we just sort of we just sort of take it for granted that the Supreme Court is this sort of special body that's an objective arbiter of the law, and we just sort of take whatever they say for granted. But the thing with that is, if you look at the way that functions in practice, the Supreme Court contradicts itself all the time, and has a rich tradition of doing so, depending on the political composition of the bench. So what we're always talking about here, as we are now, in the discrepancy between the way the John Roberts Court decided on this very issue of the right of elected officials to decide to strike the balance between public health and First Amendment rights with religion. They just contradicted themselves in a matter of what, 6 months, 7 months, and the only thing that changed was the political composition of the court. It became further right wing. So depending on the political makeup of the court, the interpretation of this Constitution, which is supposedly objective and kosher, basically shifts depending on who's on the court, what is their ideology. And that's something that sort of has been consistent throughout our history. The Supreme Court contradicts itself all the time, whether it be deciding that laws restricting voting rights. I'm quoting Matt Brunig, who discussed this in the People's Policy Project. It's a great article that I'll link to at the bottom of this clip. I've cited it before, but you can use it to say that laws restricting voting rights are disallowed, as in Harper in 1966, or say that the Voting Rights Act is disallowed, as in Shelby County 2013. You can use it to say laws restricting contraception are disallowed, as in Griswold 1965, or to say that laws requiring insurance to cover contraception are disallowed, as in Burwell 2014. You can use it to say that campaign spending regulations are allowed, as in McConnell 2003, and then say they are disallowed, as in Citizens United 2010. Now, so there's a long history of the Supreme Court. You can use the power to say school segregation laws are allowed, as in Brown in 1954, to say the school desegregation laws are disallowed, as in Parents Involved 2007. So again, the Supreme Court, basically, there is no evidence to suggest that it's ever acted as anything other than an ideological political body that's bound only by its own selfish politics. And it's generally functioned in that capacity as a force for bad. Never more so than with the Lochner v. New York decision, which was the decision that held that any regulations on worker time, hours worked by workers, or wages earned constituted a violation of the of due process, the due process clause of the Constitution, which basically amounted to an unreasonable, unnecessary, arbitrary interference with the right and liberty of the individual to contract. So basically, because of that decision, you had a 30-year period where labor laws, basically minimum wage, overtime, child labor, all that was unregulated. And you have other cases, like for example, Plessy versus Ferguson, which came off the heels of abolition, and the Reconstruction Amendments, which basically reinstated segregation, recodified segregation, by saying that basically as long as institutions were separate but equal, that there was really nothing wrong with segregation. We've seen laws. I mentioned Citizens United, which was a law that legalized corruption. We've had laws that enshrined slavery. That was Dred Scott, which was 1857 decision that really accelerated the tensions that led to the Civil War, by saying that basically the black man had no rights, that black people had no rights that the white man was bound to respect. We've had decisions that protect racist murderers. I'm quoting now Ryan Cooper of The Week in an article that I'll link below the video as well. But that was United States v. Creek Shack, which was actually right towards the end of Reconstruction. Reconstruction hadn't even ended yet, and this was basically an era that led to basically the greatest expansion of democratic rights in U.S. history. It was basically a second Bill of Rights that came out of the Reconstruction era, which obviously was in response to the Northerners, the anti-slave coalition, winning the Civil War. But the Supreme Court, shortly before that period was over, issued a controversial ruling which held that the Bill of Rights did not apply to private actors or to state governments, despite the adoption of the 14th Amendment. It reversed criminal convictions for the civil rights violations committed in aid of anti-Reconstruction murders. So basically, in general, throughout its history, and this is something that Ryan Cooper goes in great detail about, the Supreme Court has acted as a bulwark of racism, of reaction, and capitalist tyranny. So if you know that it's generally been counterproductive, with few exceptions, and Ryan Cooper cites the Warren Court's work in reversing Jim Crow, apartheid, and as the greatest example. Obviously, we've gotten marriage equality in more recent times, and in the 1950s, we struck down segregation laws with Brown v. Board of Education for public schools, and with minor exceptions, the Supreme Court has, on the whole, on balance, acted as a force for bad. An undemocratic institution that, to quote again John Roberts in his decision back in May, when the court upheld governmental restrictions that struck a balance between public health interests and First Amendment rights. An unelected body, an unelected federal judiciary which lacks background, competence, and expertise. So I just wanted to draw attention to, again, not only the way the court is tilting further right now with under Amy Coney Barrett, but given given the fact of what's happening with our government, as now Joe Biden prepares to take office and take power, be sworn in as president, and the Democrats maybe not come away with the Senate majority, the Supreme Court is going to be there to basically block progress every step of the way. And unless we take an aggressive approach in fighting back, the way that Abraham Lincoln did when he ran for president in 1858, coming off the heels of that controversial Dred Scott decision, which again upheld slavery as perfectly fine and legal and moral even, and an imperative, and banned the right of Congress to place limitations on slave property in federal territories. Coming off the heels of those two decisions, Abraham Lincoln and the Republicans, which at the time were the radical left, mounted an unprecedented in American history effort to defy the courts and in fact challenge the very institution, the very political, societal importance that we place, and the legitimacy that we place on its basically its unchecked power, its judicial supremacy. We should be thinking along those terms, I think, when we talk about advancing a progressive agenda, because the talk about court packing, which is something that Abe Lincoln actually did, by the way, court pack. He did add a seat, but it wasn't enough to make up the ideological gap on the bench. And it's something that FDR did as well, was threaten to court pack. He was not as successful. He couldn't get it through Congress, but the pressure, the public pressure campaign that he mounted with the mere threat, the mere insinuation of packing the court, and similar to the way Abraham Lincoln, when he openly defied the court and went ahead and passed laws, signed laws that came out of Congress that defied the court's orders with regards to upholding slavery as a right, the court basically backed down. You know, the court bows to political pressure as much as any politician. And I think that it's incumbent upon us on the left to broaden our thinking when it comes to this question of wresting back power, democratic power, away from an unelected federal judiciary and back towards oversight of the people via our elected officials. So I think it's important for us to think bigger, go harder when we talk about how the Supreme Court's role, in assessing the Supreme Court's role, if they're exercising an undue influence or not. Because I think in positions like this one, in which they struck down what seemed like very reasonable rights of state government officials to impose restrictions, size gathering restrictions for the sake of protecting public safety and public health, that if they're willing to go this hard this early, that we might have a long, a very big fight ahead, and we need to be thinking ambitiously and more broadly about how we want to go about advancing an agenda that doesn't run into the wall of a Supreme Court that's hostile to voting rights or campaign finance regulations or segregation or anything, you know, a woman's right to choose, you know, abortion rights, obviously. And the Supreme Court is there to be a bulwark of reaction against any progressive goals. Medicare for all, they could strike that down and say it's unconstitutional for blah, blah, blah. Debt cancellation, blah, blah, blah. You know, any one of these things, a living wage. Oh, no, this is an undue burden on the employer-employee labor contract. That's literally what they decided in Lochner back in 1905. That was what they decided. And for 30 years, we had no labor regulations because of that. So, you know, you had child labor. It was terrible. But anyway, we got to be thinking seriously about this question of how we want to handle this matter of illegitimate, undue, unconstitutional judiciary supremacy that is, again, rooted in a straight up naked power grab by the court. There's nothing in the Supreme Court. There's nothing in the U.S. Constitution that lays out judiciary review, the judicial review as a thing. That's basically self-dealing, and we got to go hard, and we can't let the Supreme Court influence our decisions. Biden is already coming out of the gate indicating that he's not willing to wield executive authority aggressively on issues in which he is empowered to under law, under existing laws that are there waiting for him to be tapped into. For example, to move us to a Medicare for all healthcare system, to cancel all $1.5 trillion of student loan debt held by the federal government, to seize patents away from greedy drug manufacturers that are gouging us and preventing people from being able to afford life-saving drugs they need, from descheduling marijuana, thus radically reforming our criminal justice system to make it more compassionate and just and fair, to prevent people, disproportionately Black and Latino, from going to prison, having their lives ruined because they smoked pot or they did drugs, some nonsense. So if Biden is going to be unwilling to exercise his executive authority that he has, and something I always talk about that he should be thinking of doing because the Constitution empowers him to, then that's one thing. But another thing is, the Supreme Court is going to actively suppress any such efforts, and we got to deal with that question too. In addition to obviously pushing for progressives in Congress to fight for legislation like Medicare for all that we need, especially now in a pandemic, and also to push senators to be able to, Democratic senators, if they regain control of the Senate, to be willing to play hardball with Republicans in getting cabinet appointments through. Biden's appointing some good cabinet picks, guys. Some of them are a mixed bag, but some of them, we gotta be fair. He's got a good Health and Human Services secretary that we need to get we need to get confirmed that Republicans are indicating they might not allow happen. And we got to be willing to be aggressive in exercising our right to bypass the Senate confirmation hearings via loophole. So again, these are all things that we got to put pressure on Biden. We got to put pressure on Senate Democrats who are publicly indicating an unwillingness to exercise the Vacancy Act to bypass Senate Republicans if they don't regain control of the Senate. And the Supreme Court is going to oppose us, obviously, on any legislation that we do pass. So we got to be willing to question and undermine their authority and challenge their authority and their right to do so. So we have numerous fights to fight on many fronts. And I think that we need to be thinking boldly, ambitiously, and broadly and creatively about how to apply the many tools in our bag, the many powers and tricks at our disposal in order to really get things done. We got right now 1 in 8 Americans saying they didn't have enough food to eat last week. 40 million on the verge of eviction. We got a lot of problems, guys. So the country is in crisis. We got 15 million Americans saying that they're $5,000 or more behind on their rent. 12 million Americans, excuse me. So it's not just COVID. It's not just COVID relief. We have a long fight ahead of us, and the Supreme Court is laying down very clearly right now that they are not going to be our allies. So what are we going to do about that?